Can you sue a judge in the High Court? Sounds dramatic, right? But today's case is even more intense. It starts as a normal divorce and turns into a multi-million-dollar legal war that climbs all the way to Australia's highest court. And along the way, it raises some uncomfortable questions. Can your assets be dragged into court even if they are not in your name? Can your family members be pulled into a divorce? And can you challenge a judge personally in the High Court? That's exactly what happened in Genesalio and Justice Jones. Today we break it down how an ordinary property dispute spiraled out of control, why it kept escalating through multiple courts, why the High Court shut it down instantly, and what this means for everyday Australians. What if your spouse's wealth is hiding in someone else's pocket? This case began in 2018 as a standard property settlement dispute. Husband and wife married for 26 years. They were separated in 2017 to 2018. Arrangements were made that the wife would have sole use and occupation of the former family home. Since that time, the husband has resided with his brother, Mr. N. Genesalio. The divorce was finalized in 2020. There were 3 adult children of the relationship. The husband submitted that he was a pensioner in receipt of pension from Centrelink in the sum of $304 per week. He had been unemployed since 2010 and suffered from poor health. On paper, it looks straightforward, but here's where it gets interesting. The asset pool was already over $5 million, but some assets weren't in their names. Imagine trying to divide a pizza, but half of the slices are sitting on someone else's table. The wife made a serious allegation. The husband's wealth wasn't really gone. It was just parked elsewhere. She claimed the husband didn't fully disclose his assets. He and his brother had been operating like a financial partnership for decades. Assets held by the brother were actually part of the family wealth. In particular, the wife claimed in 2009, the husband resigned his office in the partnership and transferred his shares in a related company to his brother for no consideration. Besides, some properties held under the name of the trust were used as security to facilitate the husband to borrow more money to acquire other properties. So the wife's argument was simple. You can't hide assets just by changing the name on the title. Why this changes everything? Because once you made that claim, this is no longer just a divorce. It becomes a forensic investigation. Now the court has to examine trust structures, company ownerships, and hidden financial arrangements. And suddenly, the brother, who has never part of the marriage, is pulled into this battlefield. Not only did the wife want to join the brother, she also sought to conduct valuation on the brother's relevant assets, including real property and motor vehicles, impose injunctions against the brother from speaking with the valuer, and force production of all financial and tax records of the trust structures. The husband asserted that he did not control those assets under his brother's family trust, as he was just a beneficiary, and his brother was the sole appointer of that trust. The husband's brother also asserted in the strongest of terms that the wife fabricated the claim with respect to the alleged partnership, and the wife's application that he be joined to the proceedings was an abuse of process. Can the court pull outsiders into a divorce? In 2023, the Federal Circuit and Family Court made a key decision. The husband's brother must be joined to the proceedings. Why? Because his rights may be directly affected, and the assets he held may actually belong in substance to the husband, and was therefore necessary for the court to determine all these disputed issues in the proceeding. Here, the court does not need to examine and test all evidence, which is a matter for the final hearing. Rather, the court only needs to be satisfied that the course of action made by the wife against the husband's brother is triable. The judge found there were serious factual disputes, possible equitable interests, and need to determine true ownership of assets. So without the brother, the case cannot be properly decided. The court eventually made orders to join the brother to the original proceeding, compel both the husband and the brother to allow access to certain real and personal property for valuation, and restrain both the husband and the brother from interfering with the valuation process. The husband's brother tried to appeal, but the appeal failed immediately. Why? Because firstly, the law prohibits appeals from joint decisions. The appeal court said, This is a procedural decision, not something you can appeal. No jurisdictional error has been identified. Secondly, the appeal court considered that the trial judge was correct to accept the wife's contention as a triable issue. That was all the primary judge needed to find. If the relevant assets are arguably earned by the husband or the wife, then they were at least capable of forming part of the joint assets to be divided. Lastly, by being joined, the brother did not suffer any substantial injustice. He still could choose not to participate in the trial. Procedural fairness only demands that he be given the chance to be heard, not that he actually takes it. What happens when the missing puzzle pieces show up late? In 2024, things escalated again. The brother delayed disclosure. Eventually, documents came out including one critical piece, a declaration of excluded beneficiaries. What does that mean? Imagine this: a trust where suddenly your name is crossed out of the will. That's essentially what this document did. It excluded the husband, the wife, and their children from receiving anything from the trust. The wife's response? She said, "This is not real. It's a legal smokescreen." What did she do? She sought to add 4 more companies and the Genesalio family trust as parties to the proceedings, expand the alleged partnership structure and assets involved. The wife said that the partnership between the husband and his brother could be traced back to 1982 as opposed to mid-1985. Also, new assets including a real property and 2 additional motor vehicles were said to be added into the assets pool for division. The wife also sought to challenge transactions. In particular, the declaration of excluded beneficiaries was said to be shams and were to be made to defeat court orders. The declaration of excluded beneficiaries turned out to be an instrument signed by the husband's brother on 20th September 2018, and in which the husband, the wife, and their children become a class of general beneficiaries that would be excluded from any distribution from the trust assets. Under Section 106B of the Family Law Act, the wife sought orders to set aside this instrument. Think of the case like a puzzle. The wife says, "I'm just adding pieces that were hidden." The husband says, "She's changing the whole picture." The wife's case is that although she sought to amend the pleadings, it was basically the same claim and same case. But because of the husband and the brother's failure to disclose information timely, she was forced to discover them piece by piece and put those missing pieces back into the basket. The husband objected to the wife's purported expansion of the case. He called the amended statement of claim as a bad pleading, abandoning the original position. The brother also objected to the amended claim, saying that it would cause delay and unfair outcome. The judge, after hearing, allowed the wife's amendment of claim and joinder of companies. Why? Because there was a triable case. The heart of the wife's case is that there is an overarching agreement between the husband and the brother, namely Genesalio Partnership Agreement. And such arrangement, the wealth generated by the businesses and investments acquired by the brothers or companies controlled by them are shared equally, and factual disputes require a full hearing. Where late amendments or pleadings are due to failure to comply with orders for disclosure, and those amendments shouldn't be rejected, even if it could cause further delay and additional costs. The court emphasized that litigation must be decided on real issues, not shut down prematurely, especially where disclosure was delayed. What if both sides agree and still fight afterwards? The matter was listed for final hearing on August 2024. Each of the parties was represented by senior and junior counsels at that hearing. The hearing proceeded over 9 days and was resolved by consent. On 30th August 2024, Justice Jones made final orders by consent. The orders included that the husband and the brother should transfer $4 million to the wife on or before 30th April 2025. The consent orders also contained default provisions that if the payment was not made by the due date, certain properties were to be sold. The orders also included a notation to the effect that the husband and the wife intended to enter into a financial agreement dealing with spousal maintenance. That financial agreement had never been executed. By June 2025, the properties were also not sold. The husband and the brother apparently refused to cooperate in enforcing these orders. Think of it like this: signing a contract, then pretending it doesn't exist. On 3rd July 2025, Justice Jones made further orders under Section 90AF and Section 114 of the Family Law Act to facilitate the sale of the properties by restraining the former husband and former husband's brother from interfering with the sale. But instead of complying, they escalated further. Can you sue judges and overturn family court orders? After filing the family court, the husband and his brother did something extreme. They went directly to the High Court. They sought to quash or stay orders made by the Federal Circuit and Family Court judge and seek constitutional relief. The husband and the brother said joinder orders were invalid because of miscarriage of justice and non-compliance with procedural fairness. By interfering in the third party's assets, the Federal Circuit and Family Court judge misapprehended the limits of her functions and acted without jurisdiction. Chief Justice Gagler, Justice Stewart, and Justice Jager convened as a full court to determine the application. The High Court refused to even hear the case fully, dismissed it without oral hearing, and refused to give any extension of time for the husband or his brother to prepare for their case. Because this is not what the High Court is for, the court found no jurisdictional error, orders were made within statutory power, no miscarriage of justice, and delay of enforcement of consent orders was unjustified. The court particularly pointed out that the husband and the brother made the application to the High Court with the purpose of delay enforcement. It was made clear that High Court is not a backup appeal court or a platform to buy additional time. It only intervenes when there is a serious legal error or constitutional significance. The lesson is that appeals have limits. Not all decisions are appealable. High Court in particular has extremely high threshold, and it rarely intervenes the lower court's decisions, especially when decisions are about facts-finding or based on discretionary powers. What happens when you keep fighting and lose? Even after losing, the husband and the brother did not comply with orders. As a matter of fact, both of them have engaged obstructive conduct throughout the proceedings, including filing appeals and refusing to facilitate appointing of selling agents. So the wife applied for enforcement again. Under Section 106A of the Family Law Act, the wife can seek assistance of the court to execute document on behalf of the husband in the face of his non-compliance with orders requiring him to do so. The court ordered indemnity costs against the husband and the brother, so they had to pay $46,000 immediately. Why? Having regarding to the long history of the litigation, the husband and the brother were wholly unsuccessful. They frustrated the proceedings so many times by trying to delay or disrupt the finalization of the matter. This is typically when the husband and the brother initially consented to the final orders through senior counsels, but then sought to challenge the validity of these orders. $46,000 is just the tip of the iceberg. This did not even include other costs incurred prior to the consent orders. Given the parties spent 9 days in trial and various appeals, total legal costs are likely in hundreds of thousands, if not measured by millions. The takeaway point is that litigation misconduct has consequences, and courts will penalize delay and obstruction. This case could affect how your assets are treated. Hidden assets are not safe. Courts can look through trusts, look through companies, and examine real control, not just the names on paper. Third parties can be dragged into proceedings. Even if you are not married and you hold legal title, you may still become a party. Think twice if you want to do a favor for your friends or family members to conceal or park their assets when relationships break down. If you would like to protect you and your family members and avoid putting yourself in a position like the husband's brother in this case, you need proper legal advice. We've worked with some of the best assets protection lawyers in Australia, so feel free to reach out to us at info@mjm.com.au for any referral or recommendations. Now let me leave you with this. Should family courts have such wide power over third-party assets? Is it fair that someone not in the marriage can be pulled into litigations? And where should the line be between asset protection and asset concealment? If you were structuring your assets today, would you feel safe? Let me know your thoughts. And don't forget to like and share if you like this video. Thanks for watching. See you next time.